Siobhan Jeffels, the Legal Director in the Family Team at Clarion, and I'm joined today by my colleague Grace Parker, an Associate Solicitor in the team, to consider the unique features of a farming divorce. So how does a farming divorce differ from other divorce cases? While the general process of dealing with the farming assets on divorce is the same as any other, the ownership structures of many farms and the common issues around liquidity of the assets can make the process more complex and challenging. For example, the assets and resources enjoyed by a couple may not be owned by them personally. A farm may have been held in the family for generations and in various forms of ownership. The assets and business may be held through a limited company with various family members as shareholders, through a trust or through a family partnership. The challenge is often working out how both spouses and the children can be provided for after the separation without forcing a sale of the assets.
So what financial information is required to get the process started? In all divorce cases, both parties must give full disclosure of their financial positions, which is usually done in a document called a Form E. In a farming case, this will include information as to how the assets are held, disclosure of the farming accounts, and information regarding income and spending. By providing as much information as early as possible to advisors, it helps to speed up the process and alleviate mistrust between the parties. How is the value of the assets decided?
So as well as legal advice from professionals such as accountants, land valuers, specialist valuers of livestock, plant and machinery, and agricultural advisors is often required. Those experts will be agreed and appointed jointly by the parties, and it's important to check that there are no conflicts if the advisors have been involved previously with the farming business. Also, the tax consequences of selling or transferring assets needs to be considered, and often advice from a tax advisor is required. So what are the options to reach a settlement?
So the court route is not the only option, and this should usually be regarded as a last resort. Alternative forms of dispute resolution, such as mediation or arbitration, can assist in achieving an agreement more speedily and economically than using the court process. Solicitors are involved in these processes by providing background advice and representation. So what does the court take into account?
Since the landmark House of Lords case of White and White in 2000, an equal division of the assets and wealth which accumulated during the marriage is considered a fair outcome on divorce. But the court does have wide discretion to achieve fairness, and this does not always mean simply splitting the assets 50-50. Inherited assets are often treated differently, and the implications of the assets on any third parties are also important to consider, but fairness still requires the parties' financial needs to be met. How to meet the needs of the parties can be troublesome where a farm is involved, as many farm assets are not easily realisable. The main family home is often the farmhouse itself, which can be the operational hub of a farm and is likely to have been inherited prior to the marriage. Often there are arguments as to whether the housing needs of the parties outweigh the desire to avoid a result that ends in the farming business or interferes with the inheritance and farming structure of a wider family. In the event of court proceedings being required, members of the family may need to be joined as parties within those court proceedings, and the courts will try to avoid the forced sale of a farm where it's been in one party's family for generations and was gifted or inherited with an expectation that it would be retained for future generations. So, for example, a spouse could be paid out over a number of years.
So what can be done to protect those assets before a divorce?
So farming families should consider the benefits of a prenuptial agreement prior to the marriage to ensure that the farm is protected as far as possible in the event of future divorce within the family. Also, postnuptial agreements are a good way to give protection after the marriage when older generations are planning to pass down assets to younger generations and want to protect the assets being lost to a future divorce settlement potentially. Also, cohabitation agreements can protect the money that's given to adult children by their parents, usually for deposit when buying a property with their girlfriend or boyfriend. Anything else to consider?
Definitely to update your will. Consider making a holding will during divorce proceedings, especially if third parties are involved and assets are held as joint tenants, i.e. where the interest of one party passes to the other automatically on death. Again, it's important to consider the tax planning aspects. If you have named your spouse as a beneficiary or executor in your will, these provisions will no longer have effect on divorce.
So Clary have extensive experience in bringing together our different teams who advise farming families, agricultural businesses and landed estates on matters such as estate planning, which is dealt with by our private wealth team, proprietary estoppel disputes, dealt with by our contentious private wealth team, and the development and how to maximise land investments by our property team. Also, low carbon energy projects are dealt with by our energy team, amongst other issues. If you require any advice or assistance following separation, where a farmer is involved, or would like to find out more about the potential protections that can be put in place, please do not hesitate to contact us.